A very good morning to all. As we all know, that 21st century has witnessed a tremendous change in the way innovations and inventions are taking place every second. The whole world is moving towards an era of growth and development. The emerging need to become well versed with changes happening around us has become all the more important. In tune with these thoughts, the Department of Computer Science, under the aegis of KCW, conducts seminars to enlighten the young minds so that they become equipped to face the challenges coming their way. Today's webinar is also a part of qualitative initiatives. It gives me immense pleasure to introduce the resource person, Dr. Vaishali Thakur, Assistant Professor at University Institute of Law, Punjab University Regional Centre, Ludhiana. Being a doctorate in law, she is an expert in the area of IPR and international trade. She has done her bachelor's in journalism and mass communication. She has many publications to her credit. At present, she is working on a project worth 25,000 US dollars with a Japanese organization that incorporates legal, political, and environmental aspects. Ma'am, we are honored to have you here on this e-platform. On behalf of entire fraternity of Department of Computer Science, I accord you a warm welcome. At the same time, I would also like to thank our Honorable Principal Ma'am for her motivational presence. She is the main source behind all the activities of college. It is only due to her encouragement and words of motivation that we are able to motivate students. Today's program is also an initiative that has been fine-tuned under her guidance. I also welcome dear students, wish you all a fruitful learning. It is time to start the interactive session on IPR, the product of human intellect that refers to brand, invention, design, or other kind of creation which a person or business has legal rights over. It's a legal framework that safeguards the interests of investors, innovators, and society at large. IPR streamlines the interests of innovators and social community. Before proceeding ahead, students, kindly keep it in mind that you have to fill attendance cum feedback form at the end of the session. The link for the same will be provided in the chat box during the session. So kindly remain active to fill the form, only then e-certificates will be awarded to you. Now, without any delay, with all humility at my command, I invite Dr. Vishali to share her experience and knowledge on the topic intellectual property rights.
Thank you, Dr. Chima. Thank you for having me on this platform. And along with that, I would like to thank you, Madam Principal, for having me here on this particular topic. And without wasting any time, I would like to start up with my topic, that is introduction to intellectual property rights. If I let me share my screen. So we'll begin with the intellectual property rights. This concept is not a new concept. If we talk about intellectual properties, in the 13th century, even in Swiss Alps, there were mining ores. There were mines, and the person who used to find those ore mines, he used to get the rights. Followed by in 14th century, in a statute of mineralia that provided for the first intellectual property rights. The if we look at intellectual property rights, they are not new. They are here since they are here because of the technology, because of the development that has taken place. So the concept is uh, now, the with the passage of time, with the developments being done, it's for us to understand what basically these intellectual properties they are. First of all, let me take you to what intellectual property is basically. If we look at a product, earlier it used to be a product. Now the creation of a mind, human creativity, when it creates something that gives you certain rights in form of property, and that is basically that gives you certain that property gives you certain rights, which is in turn is called intellectual property rights. Now, what is this intellect? Intellect is the perception which a human mind has. Human mind can do number of things. There is artificial, no doubt everything is now being done by the computers. Artificial intelligence is the new mantra, but nobody can replace the human mind. Now when this perception, when this precept that works, human mind has that, that has an objectivity, that reasons, that craves for the information, that kind of things leads to many inventions. And that inventions, that creativity, that gives birth to the intellectual property. And when that creativity is vested with rights, it becomes intellectual property rights. अब इंटेलेक्चुअल प्रॉपर्टी राइट्स में क्या हुआ कि यू डेवलप्ड समथिंग, आपने एक इन्वेंशन करा, and I tell you, it is that creativity. Ideas are not capable of getting these rights, but these ideas, when it comes to your mind, that creativity, where it becomes practical, it gives birth to a product, you get that gives birth to an expression, then you get these rights. And these rights in turn helps you, in turns, it is basically gives, in turns gives you a reward for that creativity, that mind which you have invested, that skill which you have invested in coming out with that expression, or with that product, or with that new invention. So whosoever is working, whosoever is laboring on that particular thing, no doubt he deserves a special award. And special award, and that is what this comes in proprietary rights. And apart from that, he deserves recognition also. Edison's once was the person who had the maximum inventions to his names. He was the person who did everything. So why that, why this craving inside you to come out with new thing? Because you want certain kind of recognition. You want history to know you as a person. And apart from this, providing reward to the person who's given his who's actually put in that labor to come up with that recognition, to come up with that invention, and giving that recognition. Another most important thing is the maximum benefit to the maximum members, which is the utilitarian theory. It says, this utilitarian theory says that whatever invention doing, if it is kept under the covers, if it doesn't come out, it will not yield benefits to the people. If that that invention comes into the uh, into it comes into the limelight, and everybody knows that, and everybody starts using that, then that invention is important. And that if it provides maximum benefits to the maximum members, it will it will push our economic growth, it will push the growth of that person who's invented that particular thing. So in a way, intellectual property rights are the ways to reward the human creativity, and to fasten the economic growth, and to make people get the benefits of that particular invention. So this is very important. This is what intellectual property that does to us. Now what we need to, for this this creation, how in what kind of category of property it falls in, for this we require to understand the concept of property. The concept of property has changed over the time period. If we look at it, पहले we used to, पहले creativity was in the form of the discoveries. We did this discovery, okay, this is, then it shifted from discovery to the inventions. And in these industrial revolutions which took place, they actually changed the entire scenario of the property. Industrial revolution, first industrial revolution, in that there was mechanized production, one or two production. Then Industrial Revolution 2 came, which talked about the electric productions, the number of the production, the means of the productions, they became faster, and people started making many things. And Industrial revolution 3 actually completely took over, and that it actually got into the mass production. But now the industrial revolution, which is now being called industry 4.0, is creating a new world where automation, internet, artificial intelligence, they are playing very significant role. They are changing the entire dynamics and the concept of property. And these concepts, they are reflected in the property. Artificial intelligence is one thing. Now you are not supposed to do anything, everything will be done by the robots. Everything has become, since you the students of computer science, you know it better, that how this intelligence that is playing its role. Everything is computerized nowadays. Everything, these softwares, they are playing their roles, and these robots, they are playing with the technology, and they're taking technology from one level to the another. Now, this in this particular industry, in 4.0, industry 4.0, the importance of the intellectual property rights, that has grown many-fold. आज की date में, if we talk about the latest, the example of the intellectual property rights, is the coming out of this vaccine for the COVID. In this pandemic, we've come up with this vaccine. The number of states, they were trying for this vaccine for this pandemic, for this COVID-19. And what happened? Two Indian companies, they have come up with their different vaccinations, and they have got separate patent for those vaccines. Nobody else can produce it, so they have exclusive right, that provides you the exclusivity to they provides the exclusivity to these companies to manufacture or to produce that particular vaccination. So it is basically a monopoly right, which is being given to you, and you can utilize the way you want to it. You can license it. That is what. But let's right now, let's focus on to property now. So what is property? A property. When we talk about property, what is a property? Property is something, which has some kind of existence, which can be possessed, which can be owned. But this property which has some proprietary rights attached with it. So when we talk about, and the meanings had been changes has been changed with the industrialization every now and then. So what basically property is? Property means that a thing which has got some value to it. Now, this property can further be categorized into corporeal and incorporeal properties. Corporeal properties are your tangible properties, which has some kind of existence and which can be touched. And this corporeal property can further be classified into movable property and immovable property. Movable property, which moves with you. You're wearing some jewelry, you carrying something, you have a car. So that is your movable property. And immovable property, which is fixed, which is owned by you, but you cannot take it along with you. That is your land, house. That is. And the second part of property is incorporeal property. Incorporeal property means which cannot be touched, which is intangible property, and it cannot be touched. And that is further categorized into two kinds of properties: property in encumbrances and property over immaterial things. So, property in encumbrances means that property actually belongs to somebody else. But what as a mortgager, what I have got, somebody has mortgaged that property to me. So in mortgage form, I'm getting about, how these industrial, the definition of the property has changed or evolved with the industrialization. Industrial Revolution 1 talked about the mechanized production. Then Industrial Revolution 2 talks about the electric production, and then Industrial Revolution 3 talked about the mass production. But it is that fourth industrial revolution, which they are now being called, which they are calling Industry 4.0. They are talking about this revolution has changed the entire dynamics of the property. It's talking about automation. It's talking about artificial intelligence. It's the time of the uh, artificial intelligence, and intelligence has changed the entire dynamics. So the changes in property, they are very fast. And that led to the growth of intellectual property rights, and that has given intellectual property right great value, because the kind of developments, the kind of inventions, the kind of products which are coming in front of us, people want those things to be protected. If I talk about the concept of property, and property can be classified into two categories: corporeal and incorporeal. Corporeal property, which has some kind of existence, which is tangible property, and that is you have car, you have jewelry, you have a mobile phone. That is your movable property. You can take it away, take it along with you wherever you're going. But there's certain kind of property which you own, which you possess. There are two elements attached to the property: owning it and possessing it. So then you have a property, you have a house, you have land, you have mall, you have shop. So that is, what is that? That is your immovable property which is attached to the earth. So that, no doubt, you have ownership, you have possession over that right property. But as far as the second aspect of property is concerned, that is incorporeal property or intangible property which cannot be touched, and that is further classified into property in encumbrances. That is leases, share, bonds. All these properties you have, but you do not have the actual possession of that property. So you are the owner, but you do not have the possession of that property. Then comes property over immaterial things. This is the kind where your intellectual property rights they have. You own that property. You say that you own that property, you possess that property. But what happens here is, uh, you know you might not be having a property, you might not be having that, uh, you might not be having, you do not have possession of a particular thing. Let's talk about, I'll give you one very beautiful example. You're having one cell phone at your um, with you. In this cell phone, you have number of softwares. Let's talk in the terms of the computers. Now, what happens? There is Android software. अब आपका Android software जो है, you say that you have this phone and all the softwares which you are having in this phone are your softwares. No, that is not there. You have that software, you are using that software, but the actual propriety right, they exist somewhere else. They are with the person who has developed that software, and that software is developed by somebody else. You can use it, but you cannot do anything else with that software. You cannot further sell it. You can have it, you can destroy your phone, you can throw it. You do not want to use that software, you will not throw it, you've paid money for it, but you cannot do anything besides that with that particular property. So that is what, no doubt possession is with somebody else. The use, the ownership is with somebody. The ownership, if I say, people have this kind of in people have this kind of thinking that they are the owners of this particular Android software which is there in your phone. But no, ownership lies somewhere else, and that person is the copyright owner of that software, and that is where this is how you get the rights over the intellectual property rights. And this is it is in the bracket of incorporeal, intangible, and property of immaterial thing. अगर आप सोचो तो it is nothing, but if you think, it is everything. So this is the kind of property we are going to deal with. So basically, what is intellectual property right? It is rights are two kinds of rights. One is negative right and one is positive right. Positive right means like your fundamental rights, they are enjoyed by everybody. But IPR is a negative right. Negative right means when it this right, suppose I am the person who has invented, I'm the person who's invited certain things. Now, what happens here is I am excluding others, I'm excluding all other, I'm prohibiting all others from using that registered intellectual property, because that is registered on me. If you want to use it, you have to take permission from me. If you want to use it, you have to like get the license from me for using it. If you want to manufacture that, you have to have license from me, then only you can use it. So what basically it is a negative right, and it excludes and it prohibit rest of the people from using this intellectual property. But IPR is positive right also, but when it falls in public domain, if the term of IPR, or let's say the term of the IPR patents is complete, that is 20 years, agar wo khatam ho gayi, it falls in public domain में आने के बाद it can be exploited naturally, then it becomes positive right. Otherwise it's not a positive right, it is a negative right. And these are individual rights, these are not societal rights, these are not community rights. ये rights जो हैं वो individuals को वेस्ट किए जाते हैं, या एक किसी ग्रुप को वेस्ट किए जा सकते हैं, या किसी जिन्होंने उसको राइट को क्लेम किया है. These will be given to, these are not fundamental, like fundamental rights, these are not your community rights, these are given to the number of and you can have these rights by way of registration. You have to get your patent registered, you have to get your copyright registered, you have to get your trademark registered, everything you have to. And they are granted to you for a short period के लिए आपको मिलता है, and then it becomes societal or community rights. अगर हम बात करें ना, so this is in a way, these rights are negative rights, because these are in a way guaranteeing the person that whatever you have invented will not be exploited by somebody else. They are giving them a protection, and protection to the inventor. See, you have invented, you will reap benefits of your invention. पहले क्या होता था? If we look at intellectual property rights की हम बात करें, तो look at the time, ताजमहल बना, ताजमहल बनाया, तो what the शहनशाह did, the people who made the ताजमहल, उन जो कारीगर थे उनके हाथ काट दिए गए, their limbs were chopped off. So what they wanted, they never wanted to recreate, uh, another structure like Taj Mahal. So those people who has built that structure, उनके हाथ काट दो, वो क्रिएट नहीं कर सकेंगे. So same happened with एकलव्य. एकलव्य ने क्या किया? एकलव्य का द्रोणाचार्य ने, उन्होंने उनका थंब काट दिया. थंब कटवा दिया क्यों? बिकॉज जो टेक्निक्स उन्होंने अर्जुन को सिखाई थी, he doesn't want that anybody else should know that these are the techniques of warfare which are used to be. They want exclusivity to it. So there were insecurities, and people used to adopt to different ways, different measures which were illegal for protecting those things. But now, with these intellectual property rights coming in, your rights are protected legally, and you don't have to get into illegal things to protect your properties. Now, what kind of these properties are and how they are protected? So that is what our next topic is. So there are different kinds of IPRs. There is copyright, trademarks, geographical indications, integrated circuits, patents, industrial designs, trade secrets, protection of plant varieties and farmers' rights, and protection of biological resources or protection of biodiversity. So these are different kinds of intellectual property rights which are there. Now, let's discuss all of them one by one. So let's first of all, I will be taking up copyrights. What is a copyright? अब copyright क्या है? This is a right which is given to a person, to protect his efforts in fields of arts, drama, music, choreography, cinematography, sound recordings, computer programming, literature, everything. So what basically copyright is? This is a right which is, आपने कोई novel लिखा, अब आपने एक नॉवल लिखा, नाउ you've written a novel. अब वो novel came into publication, and that novel came into publication, and people in the society, they bought that novel. What happens thereafter is, अब वो novel खरीद लिया गया, अब everybody is thinking that we've become owner of this novel. But you know what maximum you can do with that novel? You can read it, you can read it, you can tear it off, you can burn it. But what else? What besides this you can do with it? You cannot do anything with it. Reproduction is the right, इसका आपने उसको publish कराना, that is the right which is vested with the novelist. अगर novelist चाहता है कि उसको republish किया जाए, so he will enter into contract with the publisher and he will publish it. So you can just read it, you can tear it off, you can burn it, but you cannot do anything beside anything with that novel, because the intellectual property right, the copyright is with the novelist, is with the author who has written the book. You cannot edit that novel, you cannot make improvement upon that novel, you cannot publish the second episode of that novel. Those rights are with the author. So author is legally the owner of copyright in that particular book. वो book का editing वो कर सकते हैं, उसको उसका second episode निकाल सकते हैं, उसका कुछ भी करना है. So same way, same goes with the same goes with the आपने कोई म्यूजिक क्रिएट किया है तो उसका जो म्यूजिक का जो राइट है, दैट जिसने कंपोज किया है, इट स्टेज विद दैट पर्टिकुलर पर्सन, अब उनके पास रहेगा. तो कॉपीराइट इन अ वे गिव्स प्रोटेक्शन टू द एफर्ट्स व्हिच आर देयर इन द फील्ड ऑफ आर्ट्स, ड्रामा. आपने कोई प्ले, अच्छा अब आपने क्या बोला कि आपने एक लव स्टोरी है, देयर इज अ लव ट्रायंगल. अब एवरी मूवी हैज अ लव ट्रायंगल. अब वो बोलते हैं, दे फाइल अ सूट कि दिस कैन नॉट बी this cannot be utilized because we have utilized it. You know, idea is itself is not copyrightable. आपने love story बनाई और आपने बोला it is a love triangle, that is not copyright. What is copyrightable? The expression which you have given to that idea. अब उस love story को आपने कैसे express किया, that makes your thing different and that will give you कॉपीराइट. नॉट एन आइडिया कि आपने बोला मैंने आइडिया कर दिया कोई, ये मैंने दिल में सोच लिया कि दिस इज विल बी द ट्रैक एंड दिस इज हाउ इट हैज टू बी प्रोटेक्ट. नो, व्हेन इट कम्स टू एक्सप्रेशन, देन ओनली your copyright, you will get copyright over that particular thing. Since used computer sciences students, you know the section 25 FFB of the Copyright Act 1957, that defines the computers, and that says that, you know, and that provides the protection to the software, you know, and so computer software is copyrightable. And that is, you know, अगर आपने कंप्यूटर में कोई उसके हार्डवेयर में कुछ डेवलपमेंट किया है तो वहां पे आपका पेटेंट, यू विल गेट द पेटेंट बिकॉज दैट इज हार्डवेयर. व्हेन इट कम्स टू सॉफ्टवेयर यू विल गेट प्रोटेक्शन अंडर Copyright Act. So that is how your copyright, that will be protected, your software, that will be protected. Nobody else can use that software. If somebody uses it, it will be an infringement of the copyright and you will be punished according to the law. Then comes the second kind of the intellectual property rights, that is your trademarks. And what are these trademarks? You know, these are you know, if I talk about what are the trademarks, trademarks are the marks of marks which are used in course of business or trade for goods or services to give distinctiveness to the goods or services. You know, this is something which I have, this is my goodwill which I've earned over the years in the market. You know, I have strived for it and I've earned a goodwill. And if somebody else's use that, somebody else use that trademark, that will be violation of my goodwill. You know, that will be violation of my right which I've earned over the years. So what basically trademark is the visual representation of goods and services. You know, जैसे आपका let's say आपका मर्सिडीज का एक इन कीप द फेथ का साइन जो है वो मर्सिडीज का सिंबल है. अब कोई और कार आती है और इट स्टार्ट्स यूजिंग दैट सिंबल, पीपल विल फील दैट इट इज मर्सिडीज बट इट इज नॉट मर्सिडीज. सो इफ somebody is using that copyright, it will be, if somebody is using that trademark, it will be the infringement of the trademark. आज की डेट में what you were seeing is everybody is wearing a super dry t-shirt or super dry pajama, or they are wearing, what is that? That is not original super dry, but what they are doing, they are they are violating the trademarks. So the violation of trademarks is not only that you have just picked up the you just picked up the trademark and put it on something, and it is the violation or it is the infringement of the trademark. Sometimes what happens, you pick up something which at very first looks like a symbol. If you are copying it in a deceptively similar manner, you want to tell people, you've आपने eclairs की टॉफी लिया, eclairs की टॉफी का जो कवर है, that is उसको बिल्कुल सेम रखा, बट वहां पे एक्लेयर्स की जगह आपने ECLAIR की जगह आपने ACLAIR लिख दिया. Now people will have that impression and looking at the wrapper of that toffee that this is eclairs, and they will pick it up and they will eat that candy. So what is that? That is what you are doing. You will say, no, we have not copied anything. They are eclairs, ECLAIRS, and we are ACLAIRS. It is not the violation of trademark, but actually what you are doing, you are violating, you are actually doing the infringement of trademarks of somebody else. So that is violation, and that needs to be registered. Copyright के बारे में I forgot to tell you, copyright को अगर आप register नहीं भी कराएंगे ना तो भी चलेगा, because from the day of the publication you will get the copyright in that, but you have to prove that it is published. But it is published and you have to, अगर आपका published है तो then you need not to. But trademark में क्या है, you have to get it you have to get it registered to get the protection. So registration of trademark is mandatory. अगर आप इसको register कराते हैं तो you will get remedy under the trademarks act 1999. अगर आप इसको register नहीं कराते हैं तो it will be an offense of passing off, and there you will get remedy under common law, under common law, which will be called passing off. So trademark में क्या है, Basant ice cream, they are a trademark. Raymond's is a trademark. All these are trademark. Coca-Cola is a trademark. So there are different trademark, registered trademarks, service marks. So all these marks, they need to be registered to get the protection, and the term of the trademark is lifelong. Whatever you're doing, you have the right to keep that trademark with you, but you need to get it renewed after every 10 years for the maximum protection. So this is what trademarks is. Trademarks is basically my goodwill, which I have earned over the years in the form of a mark, which can be any mark, symbol, name, alphabet, numeric, color, or any combination, or that is the trademark. Now let's move on to the third category of intellectual property rights. It is your geographical indications. Now when you hear of Kulu shawls, when you hear of Kani shawl, or when you hear of Kanchipuram saris, or you hear of Chanderi saris, all these, they actually, when you say that I've got Kantha from Bengal, तो आप नकाशी कांता, अब आप क्या कहते हो, you have that kind of feeling in your mind, you have that this particular thing belongs to that particular area. So what is that? So geographical indication means कि आपका identification, these identification is basically an identification which identifies certain goods that they are manufactured, or their origin is at some particular locality and is of specific क्वालिटी. अब आपका क्या है कि अब आपको फीलिंग आया ना, कांथा आया तो आपने कहा अच्छा ये बंगाल से आया. कुल्लू शॉल है, okay, it must be from Kulu shore. Then it is Kulu apple, okay, it is from the Kulu apple. Day before yesterday I was reading this story. And I was reading this news piece. जिसमें they were talking about getting geographical indication for red maize. Red maize के लिए in red maize, and that they were saying that we will get it GI for from Chamba. So that is how these things are. So this is, you cannot, if something is from this particular region, nobody else can produce that thing and can sell kullu shawls. Ab kullu shawls ka to bahut zyada humne dekha hoga. What happens there is kullu shawls are the shawls which are manufactured from a specific kind of wool, of specific kind, from specific kind of animals. उसका जो एक वूल बनता है उसका स्पेसिफिक वीविंग करके जो शॉल बनता है, दैट इज कुल्लू शॉल. नाउ people identify it. But now what happens in Ludhiana is that people just go and manufacture those designs and patterns on machines, and they sell them as kulu shawl. So that is creating a confusion in the mind of the buyer, and they are in fact some way hampering the quality of the original kullu shawl. So what they wanted here is they wanted the protection to those shawls, those fabrics, those cuisine. What they wanted to do is they wanted to protect those things, and they are providing GI tags that this particular thing belongs to this particular region, and it has come from this particular, this has been formed by these specifications. So that is called GI, and that is how, even basmati rice, that is also protected. There was a very famous case of under geographical indication. US wanted to protect a kind of rice called as taxmati, which was creating a name, which was a substitute for basmati. So they said that this is, then the case went to the international forum, and the decision came that only the people from the northern region of Himalayas can use the northern जो तराई region वाले हैं, they can use the basmati name for their rice. A specific produce from that region will be called basmati, and that right is with northern Indian farmers and Pakistani farmers. It is not with anybody else. So whatever rice, the rice of a specific kind and a quality produced from these two states can be called basmati. No other rice can be called basmati. So a specific aromatic rice. So that is how GIs protects the produce from a specific place or locality with a specific quality. And it's, again, it is, the term for GIs is lifelong. आपका खत्म तो हो नहीं जाता वो कि आज हमने produce करना बंद किया. It is lifelong, but you need to renew it every 10 years. The next form of the next form of intellectual property rights, these are your industrial designs. Before discussing industrial designs, I would like to go into patents, and then I will come to industrial designs. Now, what is patent? आपने बहुत लोगों को सुना होगा, हम लोग का इस पे पेटेंट है. हर चीज पे दे विल बी टॉकिंग अबाउट ये हमारा पेटेंट है, ये बुक हमने पेटेंट करा के रखी हुई है, ये कॉपी भी हमारी पेटेंटेड है, ये चीज भी. नो, एवरीथिंग वॉट एवर कम्स अंडर IPRs is not patentable. Patentable will be those inventions or those products which those pretensions which are novel, which have an inventive test attached to it, and which is capable of industrial application. So four basic contents of the patents that which gives you a patentable, which gives you patent, those are called, those things are, if if a person has developed a new product or a process, it is non-obvious, it is not, it has an inventive step attached to it, it is useful. You developed one machine, आपने कोई structure सा बना दिया, and it has no utility, then you will not get patent. If that has utility, only then you will get a patent. and which is capable of industrial application, and जिसका आप industrially apply कर सकें, वो चीज जो है दैट इज केपेबल ऑफ बीइंग पेटेंटेबल. अब आपने यू डेवलप्ड, आपने क्या किया, पेज को क्रश किया और उसको क्रश करके फेंक दिया एंड यू से कि नाउ आई वांट पेटेंट ओवर दिस. नो, यू विल नॉट गेट पेटेंट ओवर दैट. हाउ विल यू गेट पेटेंट? आपने उस पेपर को, या आपने कोई ऐसी सुइंग मशीन निकाली विच स्टिचेस द क्लोथ्स विदाउट पुटिंग द स्टिच मार्क over that, over those two pieces, then over that machine you will get patent, because it has all the features of an invention which is capable of being patented, because it is a new machine. What does it do? It stitches the cloth, it joins the cloth without putting a signet, without putting stitch mark on it, two clothes without putting a stitch mark on it. So, and obviously of that machine, there is a new thing into it, there is a new process, there is a new product. It is useful also because it is and it is useful because there will be no thick place in a cloth where it has been joined, and it is capable of industrial application. Then only you will get patent. Not everything on this earth is patentable. People talk about that I have patent on. No, only those things which are capable of industrial application you will get patent. So that is what patent is, and the license for patent is 20 years. And this thing is very important, that license is of 20 years, and after this patent has to be renewed every year. If you get the patent, then after once you got the patent, and after every year you have to get the patent, you have to get it renewed. But if you fail to get it renewed within expiry of the patent, within 6 months of the expiry of the patent, and what happens is your patent falls in public domain. Patent is not for lifelong. You will get patent over certain thing for 20 years, and after those 20 years it will fall in public domain. One point is that it falls in public domain after 20 years of the 20 years of patent is lapsed. Or second, it falls if you do not get it renewed after the expiry of 6 months. When it falls in public domain, anybody can utilize that particular patent. It won't be an infringement. If you are doing it before 20 years, it will be an infringement. But after 20 years, it won't be an infringement. So for an invention which has an industrial applicability, you can reap the benefit for that invention for maximum up to 20 years. After that, you cannot restrict that invention to yourself. It will fall in public domain and people can utilize. Even you can, किसी ने आज कोई चीज निकाली है, कल आज किसी ने कोई फोन बनाया है, तो यू कैन ऑल्सो मेक इट आफ्टर 20 years, नॉट बिफोर 20 years. आप उसको बना सकते हैं एंड एनीबडी कैन यूज इट. So that is how you get, Tesla का भी बड़ा latest case था. Tesla is a company which makes electric cars. Tesla has waived off its invention. उन्होंने अपनी इन्वेंशन को, अपनी इलेक्ट्रिक कार्स की जो पेटेंट थी उसको, दे हैव वेव्ड ऑफ दैट पेटेंट. And now anybody can use their technology and can make the electric cars. So it depends upon the individual. It depends upon your intention. How would you like, whether you like to keep it or you want to leave the patent. So that is how you will get the patent. And for patent you need to get it registered. Without registration you will not get the patent, and you have to get it registered. That is very important, and I hope I've made clear what patents are. The another thing which I'm going to talk about is, now from here I'm talking about the industrial design. Industrial design में भी जो आपको protection मिलता है ना, that is in the name of the patents. उनको बोलते हैं patents है, but it is Basically you're getting a protection under industrial design. And what is this industrial design? Industrial design is a kind of protection which is given to the shape, pattern, configuration, or ornamentation of an article. I was talking about Taj Mahal. कि ताज महल में उन्होंने उनके हाथ काट दिए. Now if in present time ताज महल का डिजाइन जो था उसको प्रोटेक्ट करना हो तो किस में करोगे? यू विल प्रोटेक्ट इट अंडर द इंडस्ट्रियल डिजाइन. यू बाय सर्टेन यूटेंसिल्स फ्रॉम मार्केट. वहां पे कई बार लिखा होता है कोई पॉट का शेप है, कोई कुकर का डिफरेंट काइंड का शेप बनाया, तो उसमें उन्होंने लिखा होता है पेटेंट पेंडिंग या पेटेंटेड. तो उसका मतलब क्या होता है? दैट दे हैव अप्लाइड फॉर दैट पर्टिकुलर डिजाइन. कोको कोला की बॉटल का एक डिजाइन है. दैट डिजाइन यू कैन नॉट कॉपी बिकॉज पीपल आइडेंटिफाई दैट डिजाइन as a bottle from Coca-Cola. So that is what. So you are getting that protection under Industrial Designs Act 2000, and it is providing you, and you will get license for 10 years. And you have to, after 10 years of the license, you can utilize, after every 5 years you have to get it renewed. So basically it is the ornamentation. कोई आपने डिजाइन प्रोटेक्ट करना है, आपने कोई ज्वेलरी का डिजाइन, किसी के जो फिजिकल ब्यूटी है, इट्स नॉट, जो टेक्नोलॉजी है दैट विल बी प्रोटेक्टेड अंडर पेटेंट्स, बट जो आपका उसकी डिजाइनिंग है दैट विल बी प्रोटेक्टेड अंडर द इंडस्ट्रियल डिजाइन्स एक्ट, और उसको हम इंडस्ट्रियल डिजाइन प्रोटेक्शन बोलेंगे. आई होप आई हैव मेड माई सेल्फ क्लियर ऑन दिस पॉइंट. एंड देन मूविंग ऑन टू the next kind of the intellectual property rights, it is the integrated circuits. So what is the protection under the integrated circuits? Now when I'm talking about the integrated circuit, it is a protection which is given to the electronic chips inside the devices, and these are basically the layout designs of the semiconductor integrated circuits. So when the art, it is basically an art. You can call it art, or you can call it because in the computers, these semiconductors, or in even not only in computers, all the things they have become, they are using these semi integrated circuits. So the way you are laying out these integrated circuits, that is also protected under the semiconductor integrated circuits layout design 2000 years, and it is like you are given this protection for 10 years, and the same can be renewed. Is that clear? This is how the art of laying out of an integrated circuit is protected by way of by an act called the Semiconductor Integrated Circuits Layout Act 2000. Then comes the trade secrets. Now, when I'm talking about the trade secrets, this this particular kind of intellectual property rights does not have a legal protection specifically given by an act in India. There is no specific statute for the protection of trade secrets. If you want to protect your trade secrets, you can get relief under equity. You can get protection under law of contracts. You can get protection under Information Technology Act. But there is no protection. A specific statute has not been provided in Indian legal system. And what basically trade secret is, it is any secret having the commercial value which is not in the public domain, and which the reasonable steps have been taken to maintain its secrecy. If you see, अगर हमारा आयुर्वेदा, अगर हम पुराना अपना जो हमारा सिस्टम ऑफ मेडिसिन है, हमारा क्यों नहीं डेवलप हुआ? इफ यू लुक एट इट, हम कहते हैं इंग्लिश सिस्टम इज वेरी गुड एंड एलोपैथिक सिस्टम इज वेरी गुड, एंड दैट इज बिकॉज उन्होंने उस सबको कोडिफाई, उन्होंने उस सबको लिखा, सबको उनको टेक्स्ट में कन्वर्ट किया, एंड दैट इज प्रोटेक्टेड. उन्होंने उस सबको करके एंड दे यूटिलाइज. अब हमारा क्या होता है? इफ समबडी नोज वन थिंग, it dies with him because he does not want to reveal it to anyone, because if he reveals it, he loses monopoly over it, or he fears that somebody will have will start taking benefit of it and people will not come to him. So this way, all our Veds and Hakims who had different kind of, they had these systems. हमारे जो आपके खानसामाज हैं, the chefs हैं, if you go to Lucknow, the chefs, they have secret spices in their small small potlis, and they take out, and whenever they're making a dish, what they do is they take out that masala and then they put it in that dish, and that gives a different kind of flavor to it, and they never reveal it to anyone. Why? Because it is their trade secret. So they want to keep it protected. So since we do not have that kind of legislation, we cannot ask for its protection. But trade secrets need to be protected. And this, because these are the secrets, they have the commercial value and they need to be protected, and they are being protected, but not to the extent they need to be protected. Iski wajah se what happens is our age old secrets, they are dying with those people, those who are practicing it, they are not coming into public domain. So this is, these trade secrets are also kind of because since if I know this particular spice will go into this particular food and will enhance the flavor of this particular food 10 times, what will I do? That will not be protected. वो आपका protecting, अगर if it is not, because that is my hard work, I must have done cooking for over 100 times to realize that this particular thing is doing benefit to it. So what am I getting in return if somebody else gets to know? All my hard work goes into vain. So that is why this kind of property is there, and this needs to be protected under the Indian legal system. And after that, the protection of plant variety and farmer rights. Farmer rights may, when we talk about, this particular act gives rights to protection of plant varieties, and it gives certain rights to the farmers, it gives certain rights to the plant breeders. And this particular act, that came into limelight when the PepsiCo farmers, they filed a suit against the uh, farmers, those who were producing potatoes for those people. They filed a suit against the farmers that they are using the seed provided by us to utilize, provided by us for themselves, which they cannot do legally. What this is, agriculture earlier, it used to be, I sowed the crop, I reaped the crop, and after that, I kept some what do we call it, some seeds for myself, and or I can reuse it. This is how the agriculture used to work. Or what happened is ki I sold the seeds to the other people around in the vicinity, which the crop which I have produced. Now you cannot do this legally, since we are member of the World Trade Organization. We have to follow the norms provided by those people. If a particular quality of seed can be kept by me under this act for my personal use, but I cannot sell it to anybody else. Once a thing is packed, once a thing has a label, and you cannot sell it, even if you've produced it and it is being sold by somebody else, you cannot sell the same thing by any means, and that will be violation of that right. Whosoever is coming up with the new produce is getting those rights. So in a way, this is giving these multinational companies an edge. But यहाँ पे जो हमारी plant varieties जिनको protect करने की, if a farmer is doing something with that variety, and he's come up with certain variety of crop, he can also protect that crop by way of by taking help by getting his crop registered under this protection of plant varieties and farmers act. So it, in a way, this balance, basically UPOV convention talks about, and for UPOV convention we had this particular act, and this act basically try to create some balance between the farmers, breeders, and these corporates, and they try, and these are the right. This act basically tries to protect the rights of the farmers and the rights of the plant breeders and the rights of the and they try to protect the plant varieties. So this is how this particular this intellectual property, it is also an intellectual property. How? Because it is my thing that I have done, मैंने उसमें एक क्रॉप के ऊपर दूसरी क्रॉप लगा के मैंने उसका मिक्सिंग किया एंड आई केम अप विद द न्यू क्रॉप, सो आई नीड टू बी रिवॉर्डेड. सो हाउ विल आई बी रिवॉर्डेड? by protection of these plant varieties under this particular act. So this is the protection of plant varieties and the farm rights. And next is your our biodiversity or the biological resources. Biological resources are your animals, your plants, or your microorganisms. So they need to be preserved. They need to be preserved, and anybody whosoever wants to do any kind, or he wants to utilize these resources and they want to commercially utilize this, they need to take permission from the state biodiversity board. If he does not take these permission from the state biodiversity board, then he will be taken to the NGT, that is National Green Tribunal. So what basically we are doing by protection of biodiversity and biological resources, that if this particular act or this biological diversity act, for this particular act, the biological diversity act that has come, and it provides for the conservation of biological diversity. And it talks about that we need to use sustainably, we need to use these biological resources in a sustainable manner, in a fair and in a fair manner, and the equal sharing of the benefits arising of these biological resourcing has to be done, and the knowledge and the matters whatever are connected with it, they need to, all the people need to share the benefits which are arising out of the biological resources. And if anybody wants to do anything, whether he is Indian or Indian citizen or not, he needs to seek the permission. And when I'm talking about biological resources, I'm talking only about animals, I'm talking about microorganisms, I'm talking about plant species. But here what is not included is human genomes. Human genomes, they are not included in biodiversity. So this is how these are the kinds of intellectual property which are there. So the house is open for the these are the kinds of intellectual property. Since you've seen that these are the intellectual properties which we have, which we want to get it protected. आज की date में even a small, the smallest IPRs are of great concern to everybody. The smallest IPR holder in this world is a girl of 4 years, and she has this a patent. She has this patent to her name for a particular kind of a doorknob. So in this particular kind, if you're coming up with something new, you can protect your rights by intellectual property rights. You can contribute to the nation's growth, you can contribute to the you can contribute for your own growth, you can contribute to develop technology and industry. And it basically, and since these protections are given in a way of proprietary rights, that you are the only person who can use it, and nobody else can use these properties without your permission, it encourages a kind of research and invention in the society, and it induces these intellectual properties nowadays are inducing the inventors to disclose their discoveries instead of keeping them secrets. So, and and since these intellectual property rights are offering rewards for the expenses of for developing inventions at a stage when they are commercially practical. And sometimes what happens, uh, you've invented something but you do not have capital to to have it to capital to produce it for the maximum number of people. Now how will you do it? Now companies, they come to you with their proposals, with the contracts, and in a way it induces the capital investment, and which in fact promotes the society, which in fact promotes the economic growth of the country. So in a way, intellectual property rights, it is an upcoming area, and everybody, I think everybody in this world need to know what intellectual property rights, in order to protect their properties. You coming up with new brand. It's Ludhiana is an industrial city. If you're coming up with new brand, you need to protect your brand. If you're coming up with a new design of a particular dress, you need to protect your dress. If you're coming up with a new kind of wool, you need to protect that kind of wool. So in all that, how will you get? You will get through intellectual property rights, and that is the need of the hour. Thank you so much. Any questions? Most welcome.
Thank you, ma'am. Students, if you have a question, then please feel free to ask. Please put your question in chat box. Ma'am, someone is asking if I made a jewelry design of my own, can I get a patent over it?
No, you will get protection under Industrial Design Act. That is an ornamentation. Design. You will get a patent, but under Industrial Design Act. You have to get it registered.
The next question is, if IPR is protecting one's idea and profits from idea, then how it can be a negative right?
See, negative right, it is not. It is basically a right, but it is protecting your right, and it is prohibiting rest of the world. It is prohibiting rest of the world against that particular right. It is a positive right for the person who's got that right, but other people will be they will be prohibited to use that particular invention, and that is how it is negative right pertaining to those people who are not getting to use this particular invention.
Okay, thank you, ma'am. Next question is, ma'am, in case of logo designing, what kind of protection can be used?
Trademarks and logo designing, logos you're using for some product of yours, so it will be protected under trademark production. Otherwise, industrial design is always there.
Thank you, ma'am. Somebody is asking that whether there are any career opportunities in the field of IPR.
Yeah, you can be a patent agent who help the people in getting the patents. You can be a specification writer. These patent agents, they basically writes the specification. You can be trademark designer. You can be a patent attorney or a patent lawyer. If in case you can be a trademark lawyer. You can be an IPR lawyer as well.
One student is asking, would you please suggest how can I protect my website's content?
Websites content copyright.
Okay, thank you so much, ma'am.
And under IT Act, that is another act, Information Technology Act, where if somebody tries to, if you just want to protect the content that nobody uses that content and that belongs to you, then you will get a protection under copyright. If you published a poem, or if you've published a story, that will be by copyright. But if you want that nobody should hack it, nobody should misuse your website, then the protection is under Information Technology Act 2000.
Okay, thank you so much, ma'am. Thank you, ma'am, for such an engaging session. Your valuable inputs on IPR will surely help us in exploring this area even more. Your excellent command over the subject is really praiseworthy, ma'am. We are sure that the knowledge shared by you
Thank you
has
so much. Because of these technical, I'm not very compatible with the technology and with these technical glitches. I hope you have.
no, it was really an
I
interactive
hope
session.
you've understood the concept.
No, no issues, ma'am. We are sure that the knowledge shared by you has enriched young minds. I also seize the opportunity to thank our worthy head of the department for her motivation and guidance. Thank you, ma'am, for making us learn new things every time. I also thank teachers and students for making it an interactive session with their active participation. Thank you, one and all.
Thank you so much, ma'am.
Thank you so much.